Maybe she has to put mine. Can people take their seats, please? Kelly, are the mics on? Thank you. Thanks, everyone. As many of you have probably heard over the past day and a half, this year the Impact Fund is celebrating its 25th anniversary. I never like to let a conference go by without having all of us remember our founder, Brad Seligman, who now sits on the bench, but it was his incredible idea that was the foundation for the Impact Fund, and it was a very good idea. In celebration of our 25th anniversary, we are having a series of thought leader conversations, and the first of them was last fall at Howard University, and the topic was litigation as resistance. Today is the second of those conversations, and I have a panel that needs virtually no introduction, but I will take a minute. To my left is Sherrilyn Ifill. She is the president and director counsel of the NAACP Legal Defense Fund. Next to her is my colleague and good friend, Joe Sellers. He is a partner at Cohen Milstein and the chair of the Employment and Civil Rights Practice Group there. And next to him is Tom Saenz. He is the president and general counsel of MALDEF. And Tom has also been a member of the Impact Fund's Grant Advisory Committee and a very esteemed member for many years. So our topic today is civil rights class actions, past, present, and future. And so to get us started in terms of the past, I'm now going to give you 50 years of class action history in 3 minutes. And there's not a single one of you that doubts that I can do it in 3 minutes, is there? Okay, so let's go back to the milestones. Well, the very beginning of the modern rule is 1966. Now, obviously, there were some class actions before that. We all know about Brown versus Board of Education, but the creation of the modern Rule 23 is 1966, and 23b2 was specifically adopted to facilitate civil rights class actions. And in those early years, there was much work to be done. LDF was the leader in many of that work, and there are many people that were working with LDF. But the focus was school desegregation, employment, discrimination in public accommodations. I think the second most important milestone in that history was the Griggs decision, when the Supreme Court made clear that discrimination did not necessarily need to be intentional. Practices that had the effect of discriminating ultimately were also actionable, and those have been very important. In the years that came after, the use of class actions expanded into many areas where there were federal laws, and many of you do this work now. So national origin discrimination, Title IX, prison litigation, the Age Discrimination and Equal Pay Act, collective actions, and after its passage, the Americans with Disabilities Act and efforts to ensure the accessibility of public places to all of us, again, used the class action mechanism. We saw the first, I think, retrenchment in class actions or pushback. It started really in the early 80s and in different ways. The Supreme Court began a series of decisions that I guess carried on for essentially another 35 years, tightening and narrowing the interpretations of Rule 23. Congress did their part in restricting our ability to use class actions with legislation like CAFA, the Class Action Fairness Act, which was passed in the mid-2000s, and the Prison Litigation Reform Act, and of course we were talking yesterday about what's currently in front of the Senate, or at least has been passed over from the House side to the Senate side. And those attacks on class actions are important to understand or focus on, because the opposition is reluctant to take on the substance of civil rights head on. But by attacking the procedure and making it more difficult for us to bring the cases, it makes it more expensive, more difficult. And as our last panel was just talking about, there's the difficulty in trying to sell it to the public and explain it to the public, because it feels technical. It's hard to really, sort of get your heart into it. But that has been, I think, a very effective strategy from our opposition in terms of focusing on procedure rather than substance. Despite that opposition, as we've heard over the last couple of days, class actions continue to be incredibly important in the new areas that people are working in and developing, including the use in combating the use of criminal convictions in employment hiring, attacking the debtors' prison problems, a whole variety of criminal justice cases, inadequate foster care systems, lack of educational services for children with disabilities, deinstitutionalization of people with developmental disabilities. That's been a huge area of success with the use of class actions. And also, as we were talking about yesterday, a whole number of immigration cases. Now, class actions are not the only way that we've accomplished systemic change, and there are a whole number of important civil rights advancements that have occurred through litigation without class action. So I'm thinking about some of the voting rights and gerrymandering litigation, the marriage equality, Me Too, individual cases that have been pressing for change, as well as some of the immigration cases are done without it. But I think for all of us, in terms of the civil rights movement, class actions are a critical tool which complement legislation, grassroots advocacy, public education, and the like. So we now are facing, we've certainly been talking about a number of the threats to class actions. Obviously, arbitration, we've been talking about hostile Supreme Court, continuing narrowing of Rule 23 in the courts of appeal, corporate-pleasing legislation, as well as the sort of continuing struggle we have over public perceptions about class actions, a problem that... So with that background, the lightning round of 50 years of civil rights class actions, Sherrilyn, let me just turn and ask you first. How does LDF view the role of class actions in the current civil rights movement?
So first of all, thank you, and thank you for having me at this conference. It's been really terrific. I've only been here for a day, but I was rapt at every panel, and we have a number of LDF lawyers who are here soaking it all up for the whole conference. Much. I think I want to talk about this a little bit by pulling back. And actually, in some ways, the last panel was actually the perfect segue into what I've been thinking about class actions. And I think it was Catherine who was talking about the way in which the growth of arbitration has essentially privatized the whole concept of litigation. And the implications of that, in my view, are powerful in a democracy. One of the things that attracted me to becoming a civil rights lawyer was the idea of the kind of magic of, through the process of litigation, creating facts, right? You've got a whole bunch of allegations, you put it through the crucible of litigation, you try the case, you get to the end of the case, the judge decides the case, and issues findings of fact, and now those things are actually true. They're so true they can be relied on in other cases. You can look back on them and say that in fact happened because a judge found them. I mean, that's a powerful thing. And it's an important thing in the context of the work that we do, because so much of kind of the American public is hardwired to believe that racial discrimination doesn't exist. And so the creation of this factual record is incredibly powerful for just the very concept of inequality and of injustice. So when you think about arbitration kind of privatizing this whole thing and just removing the platform and the forum where that can happen, that's really powerful. But I think the same is true for class actions, because class actions in some ways go to the very heart of how we define inequality and discrimination. It's one thing to say that an individual has a particular interaction with a particular employer or with a particular voting registrar or with a particular school district, and to define that interaction in purely kind of private terms between that individual and who might be that defendant. But the class device was designed to actually, in the B2 context, do something very different. It was designed to actually allow for the advancement of a story about discrimination that suggests that it is structural and that it's not just individual and episodic. And so it's not by chance, right, that the rule gets codified and that, in 1966, and that these injunctive relief and civil rights class actions are created in that period. And if you look at the early cases in that period, it really is about these civil rights claims. It was a way of describing the nature of racial discrimination in this country, which is structural. And it was a way of allowing people to aggregate their claims so that they could tell that story. So when we see this move that you described, pushing back against that and compelling the disaggregation of those claims, it's doing more than something, just procedural. It's doing something more than something that makes it difficult to advance claims. It's doing something more than something that makes recovery difficult. It's actually attacking the very meaning of racial discrimination and of inequality, and attacking our ability to explain this American phenomenon, right, to the public, and to think through how you can deconstruct it. So what's been interesting, of course, is that a lot of the pushback against class actions has happened in the context of, especially in those early years, products liability litigation. And I did some of that. I spent years as class counsel in tobacco cases. And so it was kind of interesting to see the arena in which that dismantling was happening. But at its core, it was an effort to compel you to tell the story in a way that takes away a lot of its power, which is to compel you to tell a story as though what you experienced is something episodic and something individual rather than something structural. That's huge. When you talk about the value of a class action, just removing that is huge. So let me use an example, which I'm sure you all are familiar with. You remember the case Brown versus City of Oneonta, the Second Circuit case that involved the racial profiling that happened in a town in upstate New York. I think it was in 2000, in which an elderly woman was attacked in her home. She told the police that the person who attacked her she thought was African American, she thought was a man, she didn't see him, she only saw the forearm, and because the person walked quickly away when they ran out of her home, she thought the person was young. And the local constabulary in the town of Oneonta in upstate New York proceeded to question every black man in the town, including going to the state university at Oneonta and asking the state university to provide the list of black students, which the state university furnished, and questioning all of them based on the elderly woman's description that I just described. And so there was this effort to come forward with a class action, challenging the action of the police department and so forth. And the class action was challenged on the grounds that, and so the police did, they questioned every single black person in the town. And the challenge to class certification was that every interaction that individuals had with the police department was different. Some people were stopped by the police at the bus stop. Some people were stopped in the dormitory and were interviewed by the police. Some people were interviewed on the street. And on that ground, the class certification was denied, and the Second Circuit upheld the denial of that class certification. And it was actually on cert to the United States Supreme Court just when 9/11 happened. And so it didn't get much attention. It was literally the week after 9/11, and the Supreme Court denied cert. So here's a case in which each interaction, right, is deemed as its own thing, rather than the aggregated story of the way in which police officers in the town of Oneonta responded to that description and responded to African Americans in that town. Now, I'm encouraged by the fact that when there was an effort to kind of use that kind of Brown mentality in the Tyson food case, that the Supreme Court didn't go for it, right, and that Justice Kennedy didn't go for it. In Justice Thomas's dissent, he essentially offers a kind of Brown versus City of Oneonta dissent in which he says, this is the case that challenges Tyson Foods on the grounds that they're, under the Fair Labor Standards Act, on the ground that they're not paying employees for the time that they have to spend putting on and taking off protective gear in a meat plant, pork plant. And Justice Thomas says, well, each individual person spends a different amount of time putting on the protective gear and taking, it's between 0.53 seconds for some employees, and some employees take 2 minutes to put it on. But at least a majority of the Supreme Court didn't go for it. But it shows you the difference between telling a story that's aggregated, that's the whole story, that's the complete story, that is about the structural injustice, and the story that's individual. And I think that's the value we shouldn't forget when we think about what the class action device provides for us.
Tom, let me ask you to weigh in on that same question in terms of MALDEF's perception about the role of class actions in the current movement.
I think, as you've indicated historically, class actions are essential to the work that we do. I think extending off of Sherrilyn's remarks, they become even more important because of the era that we live in. And I would extend off of it that we've seen and talked about the normalization under this administration of lots of things, whether that's nativism, white nationalism, misogyny, the expectations of the language that presidents use. We've seen weekly, daily normalization of things that we were appreciated or accepted before. But I think at bottom, what we've seen is a normalization of uncertainty, normalization of indeterminacy. So that someone who sees a decision from a judge in a particular area today is more likely to conclude, whether that's a business or an individual or even a government official, that you know what, that was that day. Get another judge, get it in arbitration, I can get a different decision. Judges are biased, as our current president argued at length in his campaign, based on the judge's racial ethnic background. But there's this whole notion that we've lost the notion that there will be a consistent decision making, which makes class actions all the more essential because you can no longer rely on getting a good precedent from a district court judge or a trial court judge and the defendants that are doing similar things seeing the writing on the wall. There's no writing on the wall anymore. They think they can go and get a different decision from a different forum, from a different judge, quite easily. So risk management no longer dictates that in response to a very reasoned decision impacting an individual plaintiff or plaintiffs is going to have deterrent effect on others or cause folks to change their policies and practices that may be similar. All of that, I think, has been lost as a result of this normalization of indeterminacy, where this president acts like everything is individual to him, including judgments, including expectations, including norms, and others absorb that. And so I think we have to have then class actions that actually make sure that a decision that affects one plaintiff or two plaintiffs is going to apply to everyone who experiences the exact same thing. So if anything, I think class actions in this day and age, post-2016, are even more essential to what we do. And I would note that we always have faced these needs to use class actions because of technical idiosyncrasies of certain laws. For example, I remember 20 years ago when we first started using, together with others, preemption, federal supremacy, to challenge laws, Proposition 187, here in California. Now, one would think that when you have a structural claim, like preemption, or its opposite, the 10th Amendment, that those are the kinds of things like voting, that they're almost inherently going to be class-wide relief, because the individual, their damage, their harm, in order to remedy it, you have to fix it for everybody. But in California, our Constitution has this old provision, Article 3, Section 3.5, that says no agency can refuse to enforce a statute on the basis of its being unconstitutional until you have an intermediate appellate court decision. So we couldn't guarantee, even if we got, as we did, a good decision from a district court judge, that it would affect anyone beyond the named plaintiff. So we had to have class action, even to ensure that that structural damage being remedied by an injunction would apply to everybody, rather than simply being limited to the named plaintiffs because of that quirky constitutional provision in this very progressive state. So we have to have class actions available to us in order to ensure full relief, practical full relief for the kinds of violations we continue to see.
Joe, you want to weigh in here on class actions in 2018?
Well, thank you. First of all, it's such an honor to be here with Sherrilyn and Tom. As such distinguished leaders in the Civil Rights Forum. Real pleasure to be here. Thank you. I look back at the think about the importance of civil rights class actions from the perspective of 50 years ago when the Supreme Court recognized the principle of the private attorney general. The concept that the government cannot be relied upon entirely to secure enforcement of our civil rights laws, and that private individuals have a valuable role in the enforcement of those rights. In many ways, that model and the importance of civil rights class actions has never been more important than it is today. We've seen, as we've just heard about discussing not only in the last 10 minutes, but this the last couple of days, various ways in which the current administration is eroding by its interpretation of the law and its appointment of certain judges and pursuit of certain kinds of legislation, a variety of ways in which it is seeking to retrench the protections of civil rights. And even when you have an administration that may be more supportive of civil rights, you still have an administration that has its own political agenda. And while I don't doubt they may have motives that we may admire, they have constraints and pressures that are different than the commitments that we have to the individuals who have been aggrieved by the discrimination. And I think the importance of continuing to recognize private attorney general model in which the individuals who are themselves aggrieved, who have no other agenda than to vindicate their rights, their civil rights, don't have to worry about getting reelected or appointed or congressional oversight hearings and anything of the sort, is the purest form of the protection of these rights. And both Sherrilyn and Tom recognized the nature of discrimination is essentially class-based bias. The Supreme Court in the Rodriguez case 40 years ago so recognized, it gets lost that we seem to have forgotten, that unchallenged pronouncement from 40 years ago that discrimination is by its very nature a class-type bias and should be susceptible to class treatment. Notwithstanding that, there have been procedural challenges and other kinds of challenges that have been erected by the courts over the years, but the essence of the bias hasn't changed. It may be more nuanced, it may be harder to detect, it may require more discovery to pursue, but the bias is still there, the victims are still there, and the need to be able to pursue it on a class basis remains. Likewise, the remedies that are available and need to be pursued are every bit as much important now as they were before. And the two most critical parts are the right to seek changes to the discrimination, the injunctive relief, which most circuit courts have concluded cannot be pursued, at least broadly, without by private individuals, without a certified class. So the denial of class certification usually impairs the ability of the victims to pursue the kind of broad injunctive relief to eliminate, as Congress has demanded, discrimination root and branch. So that remedy alone hinges on the continued viability of class actions. In addition, the individual remedies are also very important. Our clients, the victims of discrimination themselves, are genuinely injured, and their injuries are often lost in the broader public debate about who should have class actions and whose rights are affected and like. But that injury is nonetheless very real. And for most of them, not to suggest that nobody can pursue claims of discrimination individually, but most often, the challenge, particularly to widespread discrimination that's really entrenched, requires class actions and requires the ability to conduct the kind of broad discovery, to spread the costs of the discovery amongst a large group of people, and ultimately to be able to secure relief that the economies of litigating claims on behalf of a large group of people can achieve. It really can't be done individual by individual. So I think we are today faced with an even greater need for civil rights class actions. We can't depend on the government to protect the rights of people for this kind of thing, and notwithstanding the best of intentions in some states, and administrations change at times, but the ability to pursue these claims as class actions, I think, is vital to the protections that Congress has bestowed on all of us to protect against discrimination.
Tom, you were talking a bit about the current administration. Do you think that there is a particular impact on immigrants and their willingness to participate in class litigation?
I think we can't separate what we're discussing from the pervasive atmosphere of fear and confusion that the administration has consciously created in immigrant-connected communities. And at its essence, that becomes a reluctance to participate in anything that might get to the government, anything that might put on record some attribute that might suggest a question about immigration status. And I think that has to affect participation in class actions. It has to affect what folks' assumptions may be about who among a class will, settlement or other resolutions, step forward and identify themselves as a class member. I think it's a real danger, this pervasive atmosphere that has been created, and it has impacts here as it does on almost any other important policy issue that we discuss. And it is a threat. In my view, it's a threat that needs to be discussed and addressed at the same level as the waivers, which, as we all know, are a major threat. But you can effectively accomplish a waiver if you have folks who are deathly afraid of participating, not even as class members, much less class representatives. And that can be a real impediment to resolving the issues.
Sherrilyn, do you think that's also?
Yeah, no, I think I couldn't agree more with that. When I first began my career as a civil rights litigator in the 80s, and I was 10, of course, but still, you know, in the cases that I litigated in some of the towns in the South where I was working, and these were voting rights cases, you know, we still had the issue of people not wanting to step forward, and so we actually did do class allegations in those cases, and there were a set of individuals who were willing to put themselves forward to kind of be the representatives. There was real fear. And I think Tom is absolutely right that the moment that we're in right now is very much like that. We forget about the protective nature of class litigation as well, that it is designed to protect that group of people, and that the class representatives are those people who are going to stand in their place. You know, we filed 2 pieces of litigation this year that kind of bear on this question. We filed a case challenging the Election Integrity Commission that President Trump created, that's now been disbanded, LDF versus Trump. And, you know, this was a case in which, again, you know, it requires a real conversation with people who might think they want to be plaintiffs in that case, right? Part of the fear, right, is that this election information that was being requested by this commission, by, you know, a commission filled with individuals who are kind of you know, the 4 horsemen of you know, voter fraud, and who insist, despite all evidence to the contrary, that such a thing as in-person voter fraud, and who believe that Latinos and African Americans, racial minorities, are the people likely to engage in voter fraud. And our suit challenged the Election Integrity Commission based on racial discrimination, on the claim that this commission was designed and was created based on racial stereotypes about voter fraud. So if you fear that the government now, this particular government, this president, who's shown himself to be vindictive and who can tweet about anyone, right? And, you know, you never forget the Boeing tweet that came, you know, after he was elected, right? You have to have a conversation with people about whether they're willing to be plaintiffs in that circumstance. Are they willing to, if the whole fear is that now they have all your information? Remember, they'd even asked at some point for social security numbers and ex-felon status and so forth. There's real fear in that. 2 weeks ago, we just filed a suit challenging the decision to rescind temporary protected status from Haitians, also based on racial discrimination. And here's yet another case along the lines of what Tom describes, in which there is real fear in the community because of what we are all seeing, because of the ICE raids, because we're seeing perfectly law-abiding people who've lived here for 40 years being taken, as they drop their kids off at school or as they, teach their classes at a community college and so forth. There is a sense of fear and panic about vindictiveness and retaliation by this administration, very similar to the fear that existed in small southern towns even when I was, first litigating about what would happen to you if you became a plaintiff in a particular case. And the class device is designed to help deal with that. It's designed to suggest that there are those who are going to stand in the place of others who, for perfectly valid reasons, cannot, will not, probably should not, stand themselves as plaintiffs in the litigation. It's a sad testament that has to be one of the reasons that we talk about the ongoing importance and vitality of class actions today, not even in the context of a state, but in the context of the federal government. That's a very sad testament, but I think there's no doubt that it's true.
Just add one more thing. I totally agree with what was said. I want to focus on another dimension of class actions that is so important to minority community, particularly the language minority community. The groups that would qualify under the discrete insular minorities have especially limited political clout, have limited community clout in their communities. They often have limited clout in their workplaces. The ability to join together to pursue common interests, to pursue common claims, offers an opportunity to cast a spotlight on the problems they're facing, to put pressure on the perpetrators of the misconduct, and to secure important relief. The weaker the groups are with respect to their ability to have political power and to command broader influence in our community, more important, I think, the ability to join together and force the public to focus on the problems that they're facing, the unlawful conduct to which they're subject, is necessary through the pursuit of class actions.
So I think one of the phenomena we have all experienced in courts is that both judges and juries are reluctant to label anyone as a racist. But interestingly, last year, the Fourth Circuit had no problem finding intentional discrimination on behalf of the North Carolina legislature. And I'm wondering what your thoughts are about that, because I found that to be a remarkable decision.
Well, let me walk you through a few others, because it's actually quite interesting. So you've got the Fourth Circuit Court of Appeals that finds that the North Carolina legislature, when they passed that Omnibus Voter Suppression Act, did so for the purpose of discriminating against African American voters, and selected the provisions of that act with surgical precision, was the language from the Fourth Circuit. We should also remember that the Fifth Circuit Court of Appeals upheld a trial court decision that Texas's voter ID law violates the Voting Rights Act, it has a discriminatory effect. But we should remember that the trial court also found that law was created for the purpose of discriminating against African American and Latino voters. When that went to the Fifth Circuit said, we're not sure about the intent. We agree it violates the Voting Rights Act. We're not sure about intentional. We'll send it back to the district court. Send it back to the district court. We went back to the district court. The district court said, no, I really meant it. It was intentionally discriminatory. And so now we're back up at the Fifth Circuit on that. So that's number two. Last year, we won a case, also in federal district court, challenging the way judges are elected in Terrebonne Parish, Louisiana, in which the trial court judge found that the method of electing judges in that county, in that parish, has been maintained intentionally as intentional discrimination. Just this week, the 11th Circuit upheld a decision part of a decision by a trial court judge in Alabama, finding that the effort of white parents to secede from a school district in Jefferson County, Alabama, was motivated by racial discrimination. And the opinion was written by Judge William Pryor, who is not a liberal judge at all. So that's just a sample of some of the cases of intentional discrimination that we're seeing around the country, in which judges are recognizing, and I want to say, first of all, and I'm sure Tom will provide the rash of cases that he has litigated that have been exceptional as well, in which there have been findings of intentional discrimination. And it's important that we recount these cases to you, because I know people say, you can't win them and you can't. So I want to give a shout out to, the legal teams that are doing an extraordinary job in litigating these cases, the MALDEF lawyers, the LDF lawyers, the lawyers of the other civil rights organizations who know how to make a record and who know how to put this evidence before these trial court judges, which is one of the reasons why it's so important that we not allow these incompetent judicial nominees who've never even been near a courthouse to get into to take on these lifetime positions, because you need judges who, whatever their political proclivities, know something actually about litigation to be able to win these cases. But it's important because it's telling you, first of all, that the evidence is so overwhelming in this moment that, whatever the political proclivity of the judges, they are compelled to find that there is intentional discrimination, which I think is powerful. I think it's powerful that that story is out there, and so people understand that this is still happening. And I think it says something about the kind of ongoing moment that we're in that kind of is revitalizing our sense of what was the purpose of these civil rights statutes. What do the Civil War amendments of the Constitution really mean? What does equal protection really mean? That it has ongoing relevance and vitality in this moment. And I think that's shaking things up a little bit. I think it's actually creating some nerves. And we're thrilled to death about it, because to be honest, this is what we've been saying, Tom and I know this, in the halcyon years of the Obama administration, when it was Brigadoon and everybody thought everything was great, we were the skunks at the garden party saying, because these cases I'm talking about, they were not filed after President Trump was elected, right? These cases come from the glory days, right? That's when this was happening, and it's as though we've kind of forgotten that. So the fact that they're coming to a head at this moment is really powerful, because it tells you about the entrenched nature of racial discrimination and how it continues to still exist in this country. The question is, what do we do with this moment when we have all of this adjudication that is saying something? This goes back to my original point, that when a judge says it, it's real. I mean, when I say it, I think I'm kind of compelling, but you may not, right? But when it goes through the crucible of litigation, right, and it comes out the other end, and a judge makes findings of fact, and the Court of Appeal says we cannot disturb the findings of fact, there is no clear error, now it's truth. It's real. And in an age of alternative facts, and in an age in which when truth is questioned, in which nothing is real, we have extraordinary power as litigators to actually help define what is real, and to have judges affirm it is incredibly powerful, and it's really up to us what we do with those affirmations. But Tom,
I would mention two cases just because I think they are something that the legal community needs to watch very carefully. So I think everyone knows that 5 years ago, the Supreme Court in Shelby County versus Holder decided that pre-clearance, the most powerful civil rights mechanism in the history of federal civil rights law, was no longer needed, that the coverage formula was unconstitutional, and therefore took pre-clearance out of effective operation. The only exception to that is when you can show intentional discrimination and you can get a judge to order a jurisdiction to be subject to pre-clearance of its future electoral changes. So, in Texas, in Pasadena, Texas, a conservative district court judge did reach a conclusion that in converting from an 8-member city council, all elected by district, to 6 districted seats and 2 at-large seats, all designed to prevent Latinos who were becoming a majority and able to control a majority of seats on the city council would not be able to do that because of turnout differentials and the outcome in those at-large seats. A conservative district judge concluded that there was intentional discrimination and ordered Pasadena to be subject to pre-clearance. Now, thankfully, as a result of the order that they revert to the 8 districted seats, a new council majority came in, a new mayor came in, and the case was settled before the Fifth Circuit got its hands on that conclusion, and the pre-clearance remains in place. But what is currently before the Supreme Court is a decision on Texas redistricting from a 3-judge district panel. And that 3-judge panel did conclude that there was intentional discrimination, a prerequisite to later getting in the remedial phase, hopefully, a pre-clearance order. Unfortunately, the Supreme Court, astoundingly, took the case before there was a remedy. So the case wasn't even a final judgment yet. Indeed, the 3 judges were at pains to say to the state of Texas, this is not an appealable order. We do not have a final judgment. Despite the 3-judge panel having done that, the Supreme Court entertained a statement of jurisdiction from Texas and decided to hear the case. And it will be heard. And one of the issues at play will be whether there was intentional discrimination or not. So I think we all need to be watching very, very carefully how the Supreme Court deals with this issue, particularly when it potentially triggers this pre-clearance obligation that the court majority in Shelby County indicated was too burdensome to the states, because we all know how sensitive to burdens the states are in comparison to the voters. But I think that the hostility that we saw there is a sign of some potential danger here. The last thing that I'll say, just because I have the ability to do it in this setting, I think it's interesting, given the last panel, I'm going to say this, that Shelby County told us that there is one alternative dispute resolution mechanism, in contrast to lopsided arbitration, that this Supreme Court doesn't like, and that is pre-clearance. Because I think we as lawyers should recognize that not only was pre-clearance one of the most effective, if not the most effective, civil rights statutes in our history, it was also one of the earliest ADR mechanisms in federal law. It saved all kinds of money for both sides, like good ADR is supposed to do, and yet the same Supreme Court very hostile to that form of ADR, no doubt, because certainly the right of states to be free from burdens is so much more powerful than poor consumers and employees.
Well, Joe, Sherrilyn's telling us that the crisis creates opportunities. So what opportunities are there for us with respect to class actions?
Well, I think one of the things I want to focus on is an area that we can take advantage of. That's social media. We have an opportunity that has really emerged in the last 5 to 10 years. We used to investigate class actions as a vehicle to bring a case, and you'd interview lots of people, and you might find some evidence, you might not, but people were much more insular. Now we have the ability to monitor and communicate between each other about difficulties people are facing in their workplace, community, with respect to obstacles to election, housing, a variety of other things, all of which can expose common practices that can and should be challenged on a class basis. And I think it's one of those opportunities we should seize, regardless of what happens with class waivers and the like. I think it presents an opportunity for us to look at class actions and the development of class actions practices that can be challenged on a class basis differently than we have ever before, and to do our homework before we bring the cases, and even after we bring the cases, to communicate amongst ourselves and not rely solely on court notice as the kind of very inflexible way in which people are informed about highly technical, judicially supervised language of what the case is about. So I think we have opportunities that we have not really, at least to my knowledge, have not really explored for using forms of communication that ways of finding common ground, that whether it finds its way into a certified class or not, provides opportunities to join together and challenge common problems. So that's one area.
Either of you have thoughts about how we use social media?
I think it's, as Joe indicated, potentially very, very powerful in surfacing areas that are constantly evolving, that need immediate attention. I, for example, would have said 6 months ago that the work that we do in immigrants' rights is entirely against the government. Therefore, not necessarily going to need the class action, because you get these structural claims, and governments usually decide to do things consistently. If the law is unconstitutional vis-a-vis one plaintiff, it's probably the rest. But just this, in the last 2 weeks, MALDEF had to file a case against Motel 6 because Motel 6 decided to involve itself in immigration enforcement by sharing its registry with ICE, and ICE then used the registry information to conduct 5 a.m. raids of motel rooms in at least Motel 6s in Arizona. Or we even filed, the Washington AG filed his own case, concluding that it was a nationwide practice by Motel 6. Now, we're just starting, and we'll decide through discovery how widespread it was, but we did file it as a nationwide class action, which I would never have expected to do in the realm of the immigrant rights work. But this came to light through media, but the media now is really so broad, it's not just what's in print. It's what comes up and gets legs in social media as well that is going to identify these new and different areas that we have to really become involved in. And in this case, again, bring class action and its importance into another subject area where we do work, which I wouldn't have expected.
Yeah, but I think, Tom, that's a really excellent point about the Motel 6 case, because I think this is a time in which it is going to be important to return to thinking about the way in which private actors become complicit, because we are in a time when there's an environment of kind of oppressiveness that is not just about the government. It is about private companies and individuals collaborating and forming partnership with the government in that. And to the extent we really recognize the ways in which our democracy is under threat right now, separating out that conduct is going to be really important. And so, suits like the Motel 6 suit, I think are just powerful. I also think that social media, so I'm on Twitter. Also, you can follow me. I did follow Paul, but you should follow me on social media. And I spend a fair amount of time on Twitter as a means of communication with people that I otherwise would not get to communicate with. And I really started to get into Twitter, frankly, after Mike Brown was killed in Ferguson, and that allowed me to engage in real time with things that were happening on the ground that were very frightening and very volatile, and allowed me to have eyewitness kind of information to deal with some of those issues. But I do think that it allows for you to understand to see momentum building around a set of practices that are affecting common people. And I saw some of that around the Motel 6 stuff. I saw a lot of that on Twitter. My own self, I had a situation in New York where I was, as unfortunately still happens in New York, where African Americans are sometimes turned down for cab rides, and so of course I tweeted it. And and I tagged the Taxi and Limousine Commission, and then they tweeted me back. And people all over the city were then started tweeting their experiences. And we had it led to a big meeting with the Taxi and Limousine Commission, and we're working with them around a set of practices. But it allows you to kind of in real time, in the moment, figure out, like, is this a one-off or is something happening? It allows you to know that something is happening, and that's important. I think as you get into class actions, I think it actually also can potentially be quite powerful around notice to class members, which is its own science, but which is a transformed science in the context of social media and understanding what are the Facebook pages, what are the, who are the Twitter leaders, where are the places where different communities who might be affected by the settlement of a class action where they might be present. So I think there are lots of potential opportunities for social media to play a huge role in helping kind of speed up and advance class actions. I'd just say I think we should be a lot more rigorous about recognizing the way in which the threat to litigation itself really is a threat to the vindication of civil rights, and that it's not an accident. And we should be mindful of that, because litigation has a lot of power, can have a lot of power for us. I know it's slow and I know it's expensive, but it also can have a lot of power, and there's a very concerted effort, I think, to take that power of litigation away, and to do the privatization and to disaggregate and to do all of those things. And I think lastly, just again to swing back around to the judicial nominations piece, to finally make it so that the system itself is not competent to even deal with litigation, right? And to begin to put judges on the bench who are completely ill-equipped to deal with the kinds of cases that we're bringing to them. And I really think we have to get more serious about challenging that. And I think those are the two things we're missing. Is one, recognizing the way all of this should make all of us activists around issues of judicial nominations, not just looking at the Supreme Court, not even just looking at the Court of Appeals. I am just like completely on fire about the district court judges, federal district court judges. I need good trial court judges who are not incompetent. And that's just it just, I'm so crazy. But it's really important. And, I learned, as when Julius Chambers was Director Counsel of the Legal Defense Fund, that you make your record. You make your record. And you need to be able to make your record, and that means you got to have a decent judge to be able to make that record. So I would really encourage people to get active when you see these trial court judges that they're trying to advance, and there's a whole tranche of them that, in addition to being hostile to civil rights, are also incompetent, right? You remember the video we saw of Matthew Peterson, the guy who hadn't litigated a case and hadn't done a deposition and didn't know what emotionally. Yeah. So okay, so you talked about it.
We had a rogues gallery.
Didn't know any of that. But we should be asking ourselves, how did he get to sit at that table? It's for a confirmation hearing. If you've seen the questionnaire, you're supposed to name your 10 most important items that you personally litigated. So what was on the questionnaire? So I just don't understand how he was at the table wasting our time. So we should pay attention to that. And the last thing is for our community, just pay more attention to trying to infiltrate the Rules Committee and really trying to influence the ways in which the Federal Rules of Civil Procedure are amended and shaped and so forth. And this goes back to the comment in the earlier panel that, we're also in a political moment. There will come a moment when we can really shape the Federal Rules of Civil Procedure for the good, so we should be thinking about, like, what's our 1966? What do we want to allow us to make the kinds of presentations that we want to make? And I think we're all, good litigators and we focus on our work, but we've got to give some of our time, some of our attention, some of our staff, some of our best and brightest to thinking about how we infiltrate those spaces where the rules are shaped.
This is something I preach about often. And I think while we all love being in the room together, this is so great. All of you need to be in the ABA, and it's painful, but that's where things start. And if you're willing to do a little work, you can really shape and change things. I was able to write the ABA's response to HR 985, which is incredibly good. So both the ABA and then obviously participating at the Rules Committee and the Impact Fund is often encouraging people and letting you know when there are those opportunities, because I think that is
the American Law Institute.
Same, really, really important. So you can't always just hang out with the people that we like. We have to go and hang out with the rest of them. So, just going back to the social media, I didn't want us not to touch on Me Too, because I think that in terms of social media was one of the most remarkable things that I think we've ever seen. And one of the things that I thought was really great was what came out of it was the creation of this Time's Up Legal Defense Fund. So the idea here was we're all outraged about what's going on, and what we need to do is have more money for lawyers to be bringing these cases, particularly for people that are not multimillionaires and movie stars, but ordinary people who have had to put up with discrimination for years and years. But it also, I think, like the cases that are recognizing race discrimination, it helps change public perception about the structural nature of sexual harassment in many industries. So I don't want to leave people feeling depressed. So let me hear what your thoughts are to send away and inspire our group.
Well, you asked about opportunities, and I think, and Sherrilyn talked about the importance of litigation, but I think we have an opportunity, and I don't know how long it will last, to really push in litigation some creative theories that previously might have been rejected out of hand. I think that what happened in November 2016 so upset people's expectations that there are judges who are now stepping up and stepping forward to accept and consider theories that previously might have been rejected out of hand. I think that's a real opportunity that we need to take advantage of. I mean, you see it in some of these intentional discrimination findings. The Muslim ban decisions are extraordinary for what they are saying to the President of the United States about what he has done. And I think that's a measure of the opportunity that we have. It will not last forever, because at some point we will either reach a point where normalization on their side succeeds and judges think, oh, this is within the realm of acceptability. It was previously defined much more narrowly, that gave leeway then to be really creative about rethinking. I told my staff after the election in November 2016 that any precedent, even if it was 40 years ago, you need to rethink whether we can challenge it again. Because what was behind that decision 4 years ago was an expectation that every presidential administration would fall within a realm of rationality and acceptability, and that's been upset, and that maybe means they start rethinking what was behind those precedents from before. But again, we'll reach a point where either normalization will have expanded and these judges will say we're still in this acceptable band, even though it previously would have been completely unacceptable behavior from the administration, or these bad judicial nominations will make it more and more difficult for us to get good, smart, independent judges making decisions on some of these. But we're in the middle of that opportunity. I think we've got to take advantage of it.
Yeah.
So I think we want to come back to something we were talking about before, and it's illustrated by some of the cases that Sherrilyn mentioned. That is that ultimately what influences courts is the evidence of the bias. If you've got strong evidence, they'll often find a way to get a class certified or do something with it. I've confronted many occasions where courts find creative ways to deal with class certification, to deal with the prosecution of the case, if they are convinced that there's a clear wrongdoing. I think it's incumbent on us, because the evidence is there. I mean, the bias is still there. It's incumbent on us to focus on the evidence of the wrongdoing or the bias, find a way to present it as squarely and vividly as we can. And I think the procedure will follow, even though it's not always clear how. But I'm convinced that at bottom, notwithstanding the concerns about the judiciary, that people will be motivated to find a way to address a clear wrongdoing. I think we're the ones to show them.
Well, you know, this is a two-edged sword. I mean, if you think about the conversation that we have been having since 2014 about police violence against unarmed African Americans, and the way in which the videos that we saw, we watched Eric Garner choked to death by New York City police officers. We saw Walter Scott running for his life in that park and shot in the back. We saw Tamir Rice killed in seconds as the police rolled up on him. We saw Philando Castile's fiancée sitting next to him narrating his death in that car. We saw Alton Sterling killed. We saw all of these killings, and an issue that had been as real can get for all of our collective careers up here suddenly entered the American mainstream, and people were able to hear, and I'll just be honest, white people were able to hear and accept something that black people had been talking about and knew to be true. And it happened because of those videos. And we are in a moment where that's what we are able to do. We're actually able to show something. And that's powerful. Now, I say it's a two-edged sword because the truth is the world I'm fighting for is the world in which, black people are believed. You don't need actual video to be believed as a citizen that an injustice is happening to you. So I'm not suggesting this is some kind of high point of democracy. I mean, it's very sad, actually. But it is true that the technology has allowed us to see something that we can't turn away from. I have been tweeting, the videos that those young people put up from the school shooting in Florida, not because I'm morbid, but because look at it. You have to look at it if you're a responsible citizen. So I think we're in a moment, and this goes to your point about the Me Too movement and the way in which social media can be used. I'm not sure if the president's aide, Porter, whatever his name was, is out of the White House without the picture, of the ex-wife with the black eye. I mean, it shouldn't take that. So this is not I'm not endorsing that, but I am saying that there is a way in which this shared ability to see the same thing at the same time. Essentially, what we're having every day is Sunday night interrupting judgment at Nuremberg to see what happened on the Edmund Pettus Bridge in Selma. Right? And the way that was a transformative moment in this country, because now people who hadn't seen were seeing what it really looks like. We're kind of having those every day. And there is power in that. And there's power and opportunity in that. The problem with them happening every day is that it's like overwhelming and it can become normalized. Mm-hmm. that we see injustice, that we see killing, and it renders us powerless. But when I say us, it just can't be us. It can't be lawyers. Like, this is what we do. And so we can't be rendered powerless. It's our job to figure out how to put that together in a way that is manageable to present and to have whatever is the injustice dealt with or the rights vindicated. That's our job. And, you know, I remember the night that Philando Castile was killed in Minnesota, and I will say this was one of the true low points for me personally. It was because Alton Sterling had just been killed maybe 24 hours before in Louisiana, and so we were, you know, we were kind of just reeling. We were looking at that video, and I remember being up with the team that night, and we were looking at the Sterling videos from different angles because we're lawyers and that's what we do. We want to know what we're talking about, and we were trying to put it together. And as we were looking at it, someone said, "There's another video," and I said, "Can't be another." Saw it on Twitter, and I said, "There can't be another video. It's probably this one, but from another angle." And then I saw that it said, "Well, there's a Facebook video," and I clicked on and I watched it, and I said to the team, "There is another video. Don't watch it. I watched it. We'll talk about it in the morning," right? And we had to then come together the next day and deal with it because that's our job. So I do feel like in this moment where we are seeing what we're seeing, all of the things that Tom described about this, I think, very dangerous moment that we're in our country, it's really our job to keep our head, you know, and to be able to figure out how we marshal this and bring that story to the judge and show that injustice and step out of the comfort zone and do exactly what Tom said. There is a way in which I do feel like ridiculously free in this moment because it's like, wow, all bets are off. We used to try to make it look very polite, but now since, you know, that's not in the cards anymore, let's try some new things. Let's, you know, let's let it rip. I mean, what do we have to do? So I do think there is a kind of a freedom in this. There is a opportunity for us if we're bold enough to step out of our comfort zone and meet the moment. And I think that's what we're required to do. You know, we all have in our heads what the civil rights movement looked like, and we look back on it and it seems so obvious it was all supposed to turn out the way it turned out, but it wasn't obvious at the time, and people didn't know what they were doing. And I have Thurgood Marshall's notes and letters, and they didn't know what's going on. And, you know, and Connie Motley would get called down to Americus, Georgia to get Martin Luther King out of jail. She didn't know, you know, why am I going? What was he doing? But, you know, I mean, it wasn't the obvious thing that it looks like when we look back. They were being opportunistic and nimble and trying to figure it out. And I think we have to do the same. And if we're going to get to the other side of this, and then when we get to the other side, there's going to be huge cleanup because a lot has already been normalized, and we can't put that back in the bottle. And we have to figure out what is that new world we're going to live in, and what are going to be the legal parameters of that new world in which, you know, we talk in certain ways and we see certain things and we accept certain things that just a few years ago we wouldn't have accepted.
Thanks, Bill.
Also.
Okay, let me throw it open for questions.
Done.
Sheila?
Yeah. I know you're optimistic.
Yeah.
And I'm generally question. I was listening to the evidence. I agree. Change. But the we're talking. You can. And how class action educated. We haven't talked about the judicial system. Is obstacle I've seen in terms of, I agree. I think that it's but I really practice our judicial system, and how do we address that?
I just want to say something real quick that, you know, what the shocking part about the moment that we're living in is that these videos did not change the outcome of any of the cases against these police officers. Even Michael Slager, who shot Walter Scott in the back, that was a mistrial. The only reason that Michael Slager is in prison is because there was a federal prosecution of him as well. And it's on those federal charges that he, you know, finally pled and he's in prison. But if we're up to the state system, even that video that you saw of a middle-aged black man running in a park and being shot in the back, even that was a hung jury. So Officer Pantaleo, who choked Eric Gardner to death, still on the NYPD. So I didn't mean to suggest that the videos changed the whole landscape. I do mean that it is a different conversation about whether this exists. One of the most pernicious aspects of discrimination is the gaslighting of the victim, which is the thing that you know happened didn't happen, which is also why the class device is so important. Because you can do that with one person, you can do that with two people, right? But you can't do it with 20, and you can't do it with 40, right? And that's part of why the aggregated claim is so important. Because the gaslighting that it didn't happen, and that was the conversation about police violence against unarmed African Americans, that it didn't happen. He struggled, he tried to get my gun, I was in fear of my life, et cetera, et cetera, et cetera, right? But now we've seen the videos and we can't unsee them. I understand they didn't change those cases, but we can unsee them. And then your point about judges and bias, no question about that. This is something, you know, that we've been talking about for years. I just saw a newspaper article the other day about the new baby judges course, you know, for the new judges. And I'm still wondering when the baby judges course is going to teach about impartiality and what that is and how it happens. Remember how Clarence Thomas said that he strips down like a runner. But he never described how does he do that, right? To become impartial, he just become magic. You put on the robe, and then this person. I mean, especially when you think about state court judges, they were running for office 2 weeks ago, right? And now they won, and with the magic of the black robe. Right? There's no real instruction about how do you, and every one of us has them. I would need some instruction to be a judge, and I have proclivities towards, you know, certain kinds of claims. And I would need some help thinking through how to manage that. So that's also part of this thing about being in the profession and the ABA and the ALI. When are we going to take that seriously about who judges are, what they do, that it is not some magical thing that comes from the sky. It's actually a job, and you have to be trained in how to manage the things that make you lean one way or another. Tom talked about independent judges. How do you become an independent judge? And we just haven't talked about that. We need to put that squarely on the table.
I also would add, I think that there's going to be, as we've seen in so many other areas, an opening up of discussion about judicial bias. One of the outcomes of these judges being confirmed who have these histories of clear, written, articulated bias against particular communities, there are going to be more recusal motions. In fact, arguably, it's malpractice for a civil rights lawyer not to file a recusal request on some of these folks who are being confirmed. Fortunately, we should celebrate that some of them didn't make it through. They had to pull out, it was so obvious. But there's still judges getting on with these documented biases. It's going to lead to more adjudications, more writing about bias in response to these recusals. As a profession, folks in this room and beyond need to try to shape how that happens, how that discussion, and then we don't know what the effects are going to be on the judges who are already on the bench and have some biases but are going to be forced because of this to start to rethink, to re-educate themselves, even without good guidance, to re-educate themselves the way that Sherrilyn was describing. They're going to have to go through some internal thinking because they're going to see it happening to their colleagues, and my hope is that leads to some positive change. And we're not going to change the bench overnight, even when we get someone else making the appointments. So we're going to have these judges on the bench for a long time, and getting them to start thinking about what their bias is, even if it's not as well documented in writing as some of these more recent appointees, I think is potentially very powerful. We can help to make it even more.
You know, I think judges genuinely believe that they're fair. And so I start with the proposition, I'm not saying they are, but that they believe that. So I think it's incumbent on us, we're in the best position to observe their conduct, their handling of trials, their handling of cases, outcomes, to be monitoring that, chronicling it, feeding it to people who can report on trends. I'm not saying it's going to happen overnight, but judges who are shown that the consequence of the last 5 rulings have all been dismissals of Title VII cases, for instance, let somebody to point that out to them in some public forum, they start to think about whether they are being too harsh on the judgment of those cases. It's not going to happen overnight. But I think we have a role to play in this, and I think we're the observers, we're the chroniclers.
Hey, and question, yeah.
When you mentioned the sexual national the legal starting with afterwards. Question: it seems like there will be a lot of unique challenges of sexual harassment environments. Just see, we steps, but now wanting to litigate class sexual harassment. Curious just any quick thoughts or feedback on when, if ever, that works.
I've litigated class sexual harassment cases actually to judgment. They're not easy. They don't happen very often, but often you are attributing the conduct to a common person or a common system that is tolerating it or encouraging it. And the Supreme Court has recognized that there may be exceptions to some of the rules that normally apply to limit discrete employment practices to promotions to certain things. Has recognized that harassment is one area where those rules might not so readily apply. We have not really exhausted that. This may provide an opportunity to do that.
One of the things that's been so interesting, I mean, repulsive and interesting, is the part of what was part of this Me Too thing was the choreography, was women seeing another woman's story and saying, "Oh my God, the bathrobe! Yeah, I remember that, right?" So that there are actually distinct common practices, right, within the context of individuals engaged in sexual harassment. And so I think that's something to kind of think about. Yeah, that makes it much. In those cases, I think you may have a much
more susceptible to class certification.
Yes, there was a story this morning about the president.
Yes.
So any other? Thank you so much. We have come to the end of our program, and I just want to remind all of you about our 25th anniversary event, which will be in early May, and you'll be hearing from us about that. I wanted to ask all of you, first of all, to thank Lindsay Nacco, who organized all of these programs. For a good part of the planning, so she really took on a lot. The rest of the Impact Fund staff, particularly Teddy Bash Witherington, Mary Jo, and also the others of our staff did a really marvelous job of making this a really smooth and wonderful conference, so I really appreciate that, all of them as well. We really appreciate all the feedback that you give us on the evaluations, and feel free to give us your ideas for next year, and hopefully we see you all again. So safe travels, and thank you so much.